can be good, I can be good, but no, I got a rebel soul. Hey, I've got a rebel soul. I got a rebel soul. Yeah, I've got a rebel soul. Hey, down with it, my rebel soul. Down with it, my rebel soul. Down with it, my rebel soul. Down with it, down with it, down with it. Just get down with it, down with it, down with it. Just get down with it, down with it, down with it, down with it, down. I've got a rebel soul. I don't cross my T's. I don't dot my I's. I won't say pretty please or speaking little white lies. I've got a rebel soul. 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 Oh, just get down with it, down with it, down with it. Just get down. I ain't no thing that you can chain with a ring. And I ain't no price for admiring eyes. I've got a rebel soul. 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 Just get down with it, down with it, down with it. Just get down. I can be good when I wanna.
I just don't wanna.
I can be good when I wanna.
I just don't wanna.
I can be a good girl when I wanna. I just don't wanna. I can be good, I can be good, but no.
Hey everybody, how we doing? Welcome in. Sorry, I hadn't heard that song in a while. I need to hear it. Needed to play some 90611 Grounds Prison Radio. How we doing? What's going on in the chat? We have a special guest here today. Would you like to show yourself? Wait a minute, I gotta take the screen off so you can show yourself. That's the only thing about the music. It's hard to see everybody. Here we are.
Hi guys, how is everyone?
Florida private investigator is in the house. Okay,
Having
so
technical difficulties, I apologize in advance.
okay, I have to tell y'all a story before we get started tonight. So Sam, I gave her permissions on my StreamYard. She comes in and the first thing she does is start deleting my content stuff that I put up. I'm like, what the hell are you doing, woman? Anyway.
I'm so sorry. It's been a long day. I apologize. It said your storage is almost full. Delete. So
I know. They're trying to get you to buy storage.
Oh God.
I
Sorry,
clean it up.
guys.
I clean it up. We're good. We've got 15 hours. And I can assure you we're not going to be on 15 hours tonight.
No. So Cindy, yeah, I do obviously live in Florida, and luckily I am now, I think, out of the cone of danger. So
Yeah, here, let me just make this update really quick. They've closed the courthouse for tomorrow. So there will be no hearing tomorrow, Thursday, but they're moved it to Friday at 2 p.m. Eastern Standard Time. I'm going to go live at 1:30 Eastern Standard Time so we can, do a little bit of chat and whatnot, okay? So, yeah. today we're going to be talking about the two motions that I've yet to go over, and that is the enlargement motion and then also the notice of intent to use the battered spouse syndrome. Sam's specialty has become the battered spouse because why is the court closed, Drunky the Bear? Because there's a hurricane. Hurricane Helene is hitting Florida, but it's going up through the Florida panhandle, so it's really not going to hit Orlando. They don't think at this time, but hurricanes can change at the last minute. So the way things have happened in the past, Florida just takes precautions just in case.
Yeah,
Okay.
exactly.
We had one time when I was in Florida that was supposed to come up, kind of sideswipe Tampa and go straight north, and then it ended up just turning at the last minute, and it went through the bottom portion of all the way into Orlando. Orlando got hit bad. That was a while
Mhm.
back, but yeah. So
Yeah,
yeah,
I've had a few close calls with them where they turn at the last minute. This one looks like it's narrowing its focus, so that's good.
I remember that hurricane because a lot of people went to Orlando to get away from it, and then it came straight through Orlando and missed Tampa where we were.
Yeah. I was evacuated once from a conference on the East Coast back to where I lived on the West Coast, only to have the storm miss the East Coast and instead come across the West Coast. I have no idea how that happened.
Oh, Shell Marie is in Louisiana. She knows. She understands. I might get a little bit of it. I mean, like I'll probably get like some rain bands or something over here in Alabama. You'll probably get some rain bands tomorrow in Tampa, Sam.
Mm-hmm.
All
Yeah.
right. So let me just welcome in if you're new here. I did see a couple of people that had made comments that they were new. Shell Marie she said she's absolutely hooked and she's new to the chat. Welcome in. We have a wonderful community here. Everyone is so kind to one another. And I think you're going to enjoy it here. And so is Zero E says, is this the Boone Club or the Hee and the Kiki Club? Well, it was formerly the Hee and the Kiki Club. Right now, they're taking over. We have Boonies taking over. That's what they call themselves. They're a little bit crazy with a side of ranch dressing, and we love it. We are here for it. Let me get to this enlargement here. Okay, so one of these, I think the enlargement hearing is the one that's 20 minutes. And then the notice of intent for the battered spouse is 40 minutes long. And we will be pausing it and making commentary. And especially Sam. Sam, you're going to have to. Oh, Sam.
Yes.
Well, you can see everything down here like I can now, right?
Yes, I'm trying to find my document. Hold on. I'm having issues. Okay.
Just let me know. Just let me know when you want me to. I'll moderate it. Just let me know when you want me to pause it if you need to say something. Okay.
Oh, what do I need to do to tell you that? Just say so?
You can speak.
I won't touch any buttons.
Permission.
Okay. All right. I'll mute myself and then I'll tell you if I need to, if I think it's a good place to stop.
All right. And y'all also say hello to your moderators, Bama Green Eyes, and I'm sure Casey might be in the house some point in time. And then also Laura, Interesting Captures. I think Laura's already here. All right, here we go. Enlargement.
Is the defendant's motion for enlargement of time filed September 17th. Mr. J, have you had the opportunity to review that?
Yes, Your Honor.
Okay, all right. Any problems with proceeding with that this afternoon?
No, Your Honor.
Okay, very good. All right, I have reviewed that motion. Mr. Owens, you may proceed, sir.
Judge, and I do have about 2 or 3 other issues that we need to address, but I've asked for some time. I think there was an order. I know there was an order that you had submitted to writing and that was filed with the clerk's file that indicated that you wanted some things from the defense and from the state by certain dates. And I think that's a typo on paragraph 3. I said August 17. That should be September 17 on paragraph 3, Judge, of my defendant's motion for enlargement of time.
That says September 5 on paragraph 3.
Are you looking at my defendant's motion for enlargement of time?
Yes, sir. Paragraph 3 says Dr. Julie Harper met with defendant Sarah Boone on Thursday, September 5, 2024. Am I looking
Margaret.
at the wrong thing?
I'm sorry. I was looking at the wrong one. If you look at the second page,
Yes, sir.
paragraph 7,
Yes.
that should be September 17th.
Yeah, got it.
Okay.
I mean, obviously, the court's order, the August 5 order speaks for itself.
Judge, and as you know, we came in late. Dr. Harbour formed an opinion that week. We filed a notice of intent to rely on battered spouse. It's ongoing. That's all I can say. We're working, we're doing everything we can to uncover evidence consistent with our defense. The problem is it's 4.5 years ago, and the apartment complex in Winter Park has changed hands. So we're trying to run down the employees. We're trying to run down the other tenants of the place. We're trying to run down medical records. That office manager is critical. We've taken her deposition, but we can't find her. Brandon, I think it's Moats, the neighbor that lived right next door to Miss Boone and Mr. Torrez, and they shared a wall, is a critical witness in the case. We're trying to locate him. As you know, 4.5 years, people move. So we need more time, is my point. We're doing everything we can. We're working diligently. Billy Lane, the investigator, is working diligently to try to gather the information I'm asking him to gather. Coupled with the fact that we've got this phone that we're going to be extracting, I'm in hopes of in a few days. And I know that the state had extracted the phone and given us a lot of the data from the phone, but Ms. Boone says it's incomplete. That's the reason we want our own expert to extract it, that will be able to assist us in establishing evidence and testimony that she is a battered spouse and was a battered spouse prior to this event. But because of that, Judge, we haven't had time to complete that. And as I said in my motion for enlargement of time, we're asking to be flexible on some time limits up to and during the week of the trial, because we're going to be working that entire trial. Like I said, there's 18 days until trial starts. It's going to be a 2-week trial. I don't know when some of this information is going to come, but I assume every other day we'll probably be amending the discovery, the reciprocal discovery, and amending the notice of intent to rely on insanity or rely on battered spouse if we find other evidence that corroborates that. So we're just asking the court, and I know there's a rule that specifically, this rule 3.050, that allows for this request. Thank you.
Thank you very much. State, any response?
Terry, can you pause?
Certainly the state.
Before you say
So-
anything, wait, Route Irish, thank you so much for gifting your 10 memberships. That's so kind. That's a lot. I don't know who got them, but thank you so much. Okay, go ahead, Sam.
I completely forgot what I was going to say.
Stop it.
I did. I'm so sorry. Did you guys catch that though? Where he said that that's the first time we've ever heard him say the self-defense for battered spouse. And so he's wanting time to do things that should have already been done that I can't believe haven't already been done. And with, I think I told somebody today, with the number of people, you have 3 lawyers. Clearly, you've got 2 assistants here. You've got Margaret back in the office. You've got whoever Henderson had on his end. So I'm stunned, to be honest with you, at the disorganization here, and that he's asking for so much time. I don't understand how you come in here asking for that much time this close to the finish. You know what I mean? Like, you knew
Well,
what you were getting into.
Yeah, and something I did, I was working on that other motion earlier today, and I noticed, I'm thinking, why don't you just go back and ask Billy Lane some more questions? Because I guarantee you that Billy Lane from Prison Break Investigations, you guys, he's like the only person that's been on this case since the very beginning. He is the lead investigator for the defense, and he probably knows a lot of this stuff. And I just feel like James is, or Jamie, whatever I like to call him, Jamie, isn't going over there and talking to him and going and asking him questions he should be asking him. Am I wrong, Sam? I mean, you're the private investigator from Florida. You know exactly what Billy's doing. Am I wrong in saying that you guys wouldn't be communicating like that with your attorneys?
I mean, with normal attorneys, we definitely would be. I don't know that anybody has worked with Mr. Owens before, and he may not be used to working with an investigator. It appears to me that he's definitely not used to working on JAC funded cases. But yeah, Billy would be the person who knows the most, who's been there the longest. And at some point, all of the discovery has passed through his hands because the judge ordered him to do that.
Bama said Billy Lane seems to be just out of the picture. Well, he's not going to be like, obviously he was only shown on camera, you guys, because there was no attorney involved at that one period of time when she was supposed to be representing herself, that short time span. And then once a new attorney came on, it was like, he's the background guy. He's not going to be, he'll be in the gallery, but he's not going to be speaking with the judge usually, or speaking with the defendant in court like he was before. I just feel like there's a lot that and somebody here made a comment. I'm sorry, it's just scrolling too fast on I think it was somebody said it. I don't know. They think maybe this is a ploy by Owens, that he's not as dumb as he's acting, and he's going to come in court with guns ablazing.
That's an interesting theory. That sounds like Dick Harpootlian from the Murdaugh trial, trying to act all bumpkiny and then comes in there all polished.
I thought that was interesting though, that he was like, oh, well, we're going with that battered spouse. And the judge is like, okay, this is the first time I've heard of that. Because the judge is even like, yeah, we what? You're gonna what? And and the judge hasn't even seen the video yet.
Right. I don't think we've even gotten to the part where the judge says he's never heard that.
Oh, we haven't? Okay. I thought that's what you were talking about.
I think, well, so Owens does say it right here. The judge doesn't catch it, because in a few minutes, what's going to happen is judge is going to say, I never heard those words come out of your mouth today. And Owens doesn't argue with him. He just keeps going. And it was like, for me, at least, it was like a mic drop, because we listened to Sarah say over and over and over again, not intentional, right? Accident, not intentional, not intentional. And then they just dropped that. So now it's self-defense.
Let me go. We'll go ahead and keep going now.
Is not going to be okay with them conducting their investigation once jeopardy has been attached. That is completely unfair to the state. This is the defendant's trial, not Mr. Owens' trial. She has been on notice of these charges since February 25th of 2020. She has gone through countless attorneys here who did not pursue this battered spouse syndrome defense, even though they had consulted with Dr. Harper back in 2020. And I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative, given her prior statements. So the state opposes any enlargement in time. The defendant has been on notice and has had centuries probably of legal expertise at her disposal for the last 4 years. And there may come a point in time where the state has to request a continuance prior to trial, but if this enlargement is granted, but certainly once jeopardy has attached, that's not the time to be doing discovery. She's had 4 years to do this, 4.5. Thank you.
4.5 years.
Any other
you
final
go, Mr.
arguments,
J.
Mr. Owens?
No, sir.
Okay. I'm just rereading the rule. Give me a moment.
Yeah, they think that the girl all the way to the right is Tony Henderson's daughter. We're not positive. We suspect. But we did find something. Yana sent me something earlier today to advise me that our two pretty little assistants here were just hired. Well, the one to the left was just hired per LinkedIn by Henderson's law firm as a, oh shoot, what is it, Sam, that they're not, she wasn't a paralegal.
Legal assistant?
Legal assistant. There she was. And the other one I haven't looked up yet. So that's just an FYI. But no, the blonde is not related to James Owens.
Oh, she's not?
No.
But we do think that the other girl is maybe Henderson's daughter.
Yeah, we're suspecting. We don't know for sure yet.
Okay.
If I find that out, I'll let y'all know.
Can I answer this question in the chat? From Bo Artful Living, dear PI Sam, any ideas on how Dr. Harper met with SB for 20 hours in 2020? I lost it. But now she claims, yeah, so that's hold on, I'm getting back to, okay, now I can see. Sorry, guys. Met with Sarah Boone for 20 hours in 2020, but now claims battered spouse syndrome. So yeah, I think you bring up an excellent point here, because it seems to me as though Harper was not willing to go there with Sarah at that time, right? I mean, for a expert to have invested that much time with the defendant and then never come forward again, I'm so honestly, I am so confused on how they think they're going to pull this off, because Dr. Harper, something must have happened there, because even when attorneys change, experts and investigators and things like that, we can stay on the case. We can come off a case, somebody else go on, and then we come back again. So I agree. I think it's kind of weird that Dr. Harper did not appear again for the battered spouse syndrome, and now we've got her back. And we know that the other guy interviewed on TV, right? Didn't you play that earlier, Carrie?
Yeah, Dr. Brannon.
Yeah, so I don't see how he can now be a part of the case, because he was giving a television interview, giving his opinion.
Yeah, apparently I missed an interview that he did. Leah was telling me that there was one that was even more recent that I haven't shown yet. So I've got to find that.
Oh,
If
wow.
y'all know that, if y'all can't put links in the chat, but yeah, I need to find that interview, because I only saw that one that I put up recently. But yeah, yes, thank you, Barbara. We thank you for your super chat, honey. We do. We've got from different countries. It's so cool. We've got people from Scotland and everything in here. Amazing. Y'all can put in the chat where you're from. Okay, I'm sorry, Sam. Go ahead.
No, we're good. I just see that people in the chat saying, that they're catching this too, about how they feel that it's strange as well. So let's continue on, and we can see how the judge reacts to this news.
Exactly. Okay.
Mr. Owens, as I stated when we had our hearing on September 3rd, at that point in time, the court had outlined the history of the case, the court's prior findings, the numerous experts that had been retained throughout this case, and I understand the position that you find yourselves in. But at the same token, based on the same analysis that the court had relied upon in its oral pronouncement in denying your continuance on September the 3rd, I'm going to grant your motion and deny your motion in part. With regard to the filing of objections to the state's exhibits, by your own statement, you're still in the process of going through those. The deadline expired on September 17th. So I believe that we're using the second portion of the rule with regard to that issue, because there was a requirement to provide those names, and this motion was filed on the 17th. So I'm going to grant your motion in part with regard to filing objections for the state's exhibits. I will give you up until the time that we're having our trial case management on September 26th to file any additional objections to any of the state's exhibits.
Were there any objections filed today?
And for those that were, no, I've already checked. For those that are coming in late, I was muted, sorry. The trial that's scheduled for tomorrow, the hearing that's scheduled for tomorrow, has been moved to Friday at 2 p.m. Eastern Standard Time. I'll check right now while we're playing this and double check the docket.
Okay.
With regard, however, to the filing of a witness and exhibit list, I agree with the state. We can't be amending once jeopardy attaches to provide additional experts or any witnesses at that point in time.
You're talking about jeopardy when the jury is sworn?
Correct.
On that Monday, October 7th?
If we're lucky enough to get one on Monday.
So
I love right here how he breaks down what he plans on doing with the juries, finding the jury. This is beauty, miss.
Just so that
I've
you
never heard
understand,
anybody say they
I've
were
ordered
ordering
a
people.
couple hundred people for that week because I don't know how long jury selection is going to take. I don't know what people know about this case.
Judge,
So my intention is to run 50 people in the morning. So I'm just letting y'all full disclosure here, what my thoughts are. 50 people in the morning, get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. Get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've got 40 people, 50 people at the end of Monday, we'll start Tuesday and we'll start whittling it down. And I can turn over when I'm done with my colloquy, my voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state and I'll turn it over to you and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case.
is this set for 2 or 3 weeks?
2 weeks. 2 weeks. Now, it was originally set for 3 weeks. And then when we talked about it, when you came on board, we had shrunk that to 2. Now, if we think that that may change, I'd rather discuss that now than a week from now. You think we need 3 weeks, I can try my best to make that happen. But I respectfully need to know that sooner rather than later. Because in all candor, I don't know how long it's going to take us
I
to get a jury.
I did not anticipate, I anticipated we were going to be able to pick a jury in one day.
I would love to be that bullish. I hope we can. I'd love to be able to. I'm just telling you what I've been working with jury services, that I've got 50 people teed up for 9 a.m. I got 50 people teed up for 1:30. And that will continue throughout the day, the week. It's easier for me to say, we don't need you, go home, you don't need to show up for jury service, than it is, I need bodies and we don't have them. Now, if we're able to get a jury in one day, fabulous.
Owen seems
But if we
flustered.
can't,
You think?
He's turning a little red.
His blood pressure is going up.
Yep.
What, Judge? I don't know. Let me call Margaret. I'm going to warn you guys right now. I don't know how great my commentary on this is going to be tonight because my head's not in it.
Stacy Hunt. So the only reason that the hearing tomorrow was postponed till Friday is because all of our courts shut down today. There is a hurricane that has moved slightly and now looks like it's going straight for the Panhandle. There's a huge storm. And there have been times when everybody was not on their best hurricane watch, and a storm the size of the one that's coming just can envelop the entire state because it's so wide. And people are not joking around anymore after Ian and all the other eyes that have come through recently.
Yeah, it's
So-
a Cat 3.
Yeah. And the judge is saying here, he's saying, I'll give you till the 26th, which is tomorrow. That's your case management conference, to file objections to the state. So
It's-
he's not going to let Owens continue to amend things like he's proposing to do. He's not going to let him do that. He says that here.
I love that the defense was probably like, well, maybe the storm will get a little bit more time. And then judge is like, nope, we can do this tomorrow. I'm going to put this conference right here tomorrow. We're not going to skip a beat.
Right. Well, so in my area, my courts are scheduled to be back open again on Friday as well. But with e-filing, because now everything in the state is electronically filed, there's no excuses. You can't miss your deadlines because the courthouse is closed. You just need an internet connection.
Yeah. And what's her name? Hang on, sorry. Mandy said that you're right. I just to check the docket, and they did all put 3 of them from the defense put in a notice that they will be appearing via Zoom on Friday. which we hope is not the crap show that we ended up watching this past Thursday when Henderson was on Zoom. Let's hope to God they learned something from that, because, Owens was in the courtroom and experiencing it on this side. So hopefully he's going to have them preset that, double check it, make sure it's okay. I do think it has something to do with the way the feed is coming into the courtroom. I don't think it's 100% on their side, although we could tell. We could tell he had never been on Zoom before, or I don't. That was strange. The way he was walking around, like he was like he had the whole screen, like you could see his whole body, but all you could see
your
was his
edit
tie.
was so funny. Your edit is hilarious.
I know,
I think he was talking to the screen and not to the camera. Oh
And
my goodness.
you just want to say, just sit down. And that poor assistant, she's like shuffling to get everything done for
Oh
him. Bless
my
her heart.
goodness. Yeah.
Mess. All right, I'm gonna go ahead and play.
I have that backup.
I believe if we pick the jury in one day, we could try the case in 2 weeks. But if it's going to take a little bit longer, and again, we don't know from now until October 7th what other evidence or what other witnesses we're going to uncover. So in the abundance of caution, I'm going to ask the court, if possible, to set 3 weeks. I don't think it's going to take 3 weeks, but I don't know how long jury selection is going to be. I don't know what additional evidence we're going to uncover, additional witnesses from now until October 7th. So to be on the safe side, I would ask for 3.
Okay, all right. I'll see what I can do there, and I'll have Anita report back to both of you.
Judge, and the main reason, I think all these other lawyers, they didn't have an expert that had tendered that opinion about her spouse. So we started on this path on that Friday when Dr. Harper called me and I filed the notice of intent to seek corroborative evidence, corroborative witnesses that she was battered. So that didn't really start until that day, which was September 6th. And that's why, and again, this was an event that occurred 4.5 years ago. Trying to locate witnesses, it's just taking time. I understand about the jury being sworn and we
Okay, Sam, this part confuses me. Trying to find witnesses? That would be Billy, right?
Correct.
Well, Billy's been on it from the beginning. Shouldn't he have been able to keep up with these guys, or how does that work?
Well, not necessarily. I mean, he may have found them at one time and gotten a statement from them or an affidavit, but it's been 4 years. Sometimes we can't keep a hold of a witness for 4 weeks, let alone 4 years. So, I mean, he can make his best effort, but at the end of the day, if people have moved or they've changed phone numbers and they're not responding, there's nothing he can do about that. I mean,
I don't understand how, when people are questioned like that in a big case like this where a family is seeking justice, how they can't get a system in place that says, okay, you're a possible witness. That means that you have to inform the courts if you move between now and when the trial begins. We'll send you a letter when trial starts, or in case, to let you know if we're not going to use you or not, or something like that. But I just don't understand how witnesses can just go do their thing. I mean, like these young guys that live next door to her. I remember when I was young and, right out of high school and all that, I wasn't worried about forwarding any of my mail or anything. They can't find these guys because they're young and they're moving around. They were in college at the time. They're probably out of college now. It's crazy.
well, you'd be surprised. A lot of people that I contact do not want to talk to me. I tell them who I am. I tell them what I do. I tell them why I'm contacting them. 9 times out of 10, they say, how'd you get my name? And I was like, well, you gave a statement to the police. And then I asked them if they would be willing to give a statement or an affidavit. And they say, no, I want nothing to do with this.
And they have the right to do that, I guess.
Yeah. So if the court subpoenas them
They don't have
and
a
they
choice.
don't show up for trial, the court can hold them in contempt. But if you can't find them, you can't subpoena them.
Exactly.
Yes, CB, they can ignore a letter from the defense. The defense has no power. The state has all the power. And the judge has more power than the state does.
That's a shame. But I will say this, though. If it was Sarah Boone's defense trying to contact me, I'd be like, no. If the prosecution wants to call me, I'll be there. I don't want to be there for her defense.
I've had people
Maybe that's
tell me
their
the same thing.
time frame. Huh?
Yeah, I've had people tell me the same thing. Like, I won't testify on behalf of that person, but I will against him.
Makes sense. All right, I'm gonna hit play.
Shouldn't be allowed to ask additional witnesses to come in. So I agree with the state on that. I agree with the court. But I would ask up until the time we pick the jury that we be allowed to amend reciprocal discovery and amend our notice of intent to add additional witnesses and additional evidence.
Mr. J, any other further positions, sir?
There just may come a point in time, Judge, if you don't set a deadline that the state has to ask for continuance.
The deadline is going to be for objections to the state's evidence, providing of a witness and exhibit list for the defense at trial case management next week, September 26th at 9 a.m., in addition to all the reasons that the court placed on the record on September 3rd during the motion to continue. My JA has advised that Mr. Lake has appeared virtually with regard to the motion to appoint clinical psychologist. Mr. Lake, can you hear me?
Yes, I can, Your Honor.
Can I get your appearance for the record, please?
Yes, Christian Lake on behalf of the Justice Administrative Commission.
All right, thank you, sir. Earlier today, before your participation, I know that Mr. Owens had provided you certain cost motions regarding the forensic psychologist, Dr. Harper, and the crime scene investigator, Dr. Birkland. You had advised as the JACS's positions on those motions. Your email has been filed in the court file. Subsequent to that, a motion to appoint clinical psychologist regarding Dr. Michael Brennan was filed. That was just filed yesterday. I know my judicial assistant sent you a copy of it. Have you had the opportunity to review that motion? And if so, what is JACS's position?
Your Honor, just briefly, we did review the motion. Although we're not contesting it beyond objecting, we do object to any rate in excess of the rates established by law, but we acknowledge for this type of expert that it would not be uncommon to approve a rate of $200 an hour. It's if that does exceed the rates established for this circuit.
Mr. Lake, I hate to interrupt you, sir. Madam Court Reporter's having a difficult time hearing you. If you could start over and slow down just a smidge for us, we would greatly appreciate it.
Not a problem, Your Honor. We did review the motion to appoint the expert. Just to give the court some background, because I went back and looked through our files. So far, the defense has incurred, this is prior to Mr. Owens' involvement, but so far the defense had previously incurred $7,500 for one mental health expert, and that's the same mental health expert as being, not this expert, but was the other expert being requested, was requested by the defense in the other motion.
Okay, let me end this and I'll come up. Was that me talking in the background or was that you?
I was on mute.
Oh, I must have been. Hang on. I didn't know that. Hang on.
Defense also incurred $1,800 for a mental health expert that was hired by Ms. Cashman. That was, let me just get the right name. I don't want to say the wrong name, but she was paid $1,800. She was retained in relation to the issue that was before the court today, the battered spouse syndrome. And now the defense is requesting a third mental health, but also at the rate of $200 an hour. Based on the nature of the case, Your Honor, we have no real, other than objecting to the rate because it does exceed for the circuit. We don't have any other concerns about the appointment of the expert. It would be the third mental health expert appointed to assist the defense. But that really, I mean, ultimately that's your call when you allow the defense to incur costs for a third mental health expert.
The motion reflects the rate is $200 per hour. Is that in excess of the JACS rate?
Your Honor, in excess of the rates for the circuit, those were the rates that were adopted back in by the old Immigrant Services Committee back in 2007. We essentially generally don't ask for a hearing unless the rate is over $200 an hour. So we generally, again, we acknowledge that is, that the rates generally range for mental health experts range between $150 to $200 an hour. So we don't particularly object to them. As far as what the rates currently.
Because this is so ear curdling or whatever they want to say. Sam, do you want to explain what's going on here? Okay. And then we'll move on.
Can you just pass them by? So the JAC has not increased their rates for experts for a very, very long time. So what Christian Lake is saying is that whatever the circuit rate is there for Orlando, like $160 or $175, the expert is willing to work for $200 an hour. So when you have an expert that will come in and do the job, but they want more than the approved rate, then you have to have a hearing, and Christian Lake has to say what he has to say. At the end of the day, it's not up to Christian Lake, it's up to the judge. And the judge here is going to grant the $200 an hour for the expert, which is insanely low. And I can tell you right now, we're having a lot of problems on my end finding other experts because they don't want to work for the pay of the JAC.
Yeah, well, that was a problem that Bankowitz was having early on with finding an expert, I guess,
Yeah.
psychologist. Yeah.
Route Irish, you would be surprised. So you're saying Sam shouldn't a half decent investigator be able to track down witnesses with today's technology? Well, first of all, let me tell you, if the person can be found, Billy Lane will find them. And people, you're right in that people do leave a digital trail behind them, but sometimes it just goes nowhere. I mean, I'm looking for somebody right now, and I'm like out of ideas on how to find them. And a lot of people, particularly in the cases that I get, which are not usually alcoholic women suffocating their boyfriends, the cases I get, people often don't have a cellular phone plan, like a contract with T-Mobile or something like that. They have the pay-as-you-go phones. And when that's in play, then it doesn't matter how much information I get. If that number comes back to me and it says no person identified, then there's nothing I can do about that.
Thank you, Route Irish, for your super chat. Are we saying that right? Route Irish?
I think so.
I think we are. Okay, do you want me to hit play again?
Yeah, did you get rid of
This is not going to be nunc-pro-tunc because I've received nothing
hang on.
from you, Mr. Owens, that he's done any
Do you
work
want me to
yet.
explain that?
Okay, so this will be effective as of today, the 17th
Oh,
of February.
non-pro-tonk?
Yeah.
You talking about non-pro-tonk?
Yeah,
Yeah,
do
it just
you guys
real
know
quick.
that? Oh,
We talked
it
about
just
it
means-
already.
Oh, okay. It just means they're backdating it. So, for example, I have a case right now where I did a bunch of work on it, but I'm out of hours. So I've asked the court to date my new order back in time so that it covers the work I've already done.
Retroactive.
September.
Yeah, is that not what I just said? I'm sorry if I said a different date. I will take it under advisement the issues pertaining to the battered spouse syndrome and provide a written order. You had advised there were some other issues that you wanted to bring up, sir.
I haven't. Shoot. Did I not edit this? Good gracious.
The
I
other
did.
thing
I did.
I want to
I
say
edited it down.
The other thing I wanted to respond to the chat about finding people is you have to remember that between
This relates to
Sarah
the
was arrested in February of 2020. Is that right? We had a pandemic.
Yep.
And I'm sorry, my cat is meowing to where you're going to hear him because my headphones were
It's
not
not that loud.
charged.
It's not that loud. Are you done? Oh, now her headphones aren't working.
Yes, I'm done. I was
Okay.
muting my cat.
Oh, okay. All right.
He's decided to be chatty.
Yeah.
Sorry.
the investigator, Billy Lane, who's working with the defense, and his potential costs up to the trial.
Are these being hand filed now?
Mr. Lane handed them to me right before we came in, so I'm going to have to scan these in and file them.
Okay.
I wanted the court to be aware. If you want to address it at the September 26th case management conference, we can do it then.
Let's do that. Just do me a favor if you could, sir. Once they're filed, just forward them to Ms. Barrios.
Okay.
So that I've got hard copies of them.
All right, I'll do
I'll
that.
give these back to you, sir.
Judge, the other thing was, of course, we've got trial coming up quickly, and generally, when in a courtroom, I do opening statement, I maybe have some demonstrative aids, but I walk around, and I understand here that we've got to be in
Oh,
front of
Lord.
a microphone. Is there any way we can set up, maybe the defense can set up a system where we can wear a mic so that we can?
Okay. Here's my thought on this. Bring your own freaking walk around mic, whatever you call that, portable mic. And we'll see if we can get it set up into the system with the courts. We'll see if it works. But I think, Sam, you had said earlier, it's all about the clerk. It's all about the lady that's taken the deposition. What is her name? What do they
The
call her?
court reporter.
The reporter. She's the one that really matters with that.
Yeah, it's most important that she be able to get a clear audio feed. And like we talked about before, different courts are set up differently, and some of them aren't set up for technology very well. And this is particularly bad, but all the courthouses I've been in usually have a tech person that you can call to come in and try to deal with whatever issues they're having. But this audio is just absolutely horrible.
Yeah. Let's hope it improves.
Walk to some degree.
I will have to check with court admin.
All right. And then the other thing is, we would like Sarah to wear street clothes. So
Fine.
do I need to
So,
file something?
I have, get in touch with the public defender's office. When Miss Boone was representing herself, I had coordinated and communicated with the public defender's office multiple times in an attempt to obtain clothing. Before you came on board, Mr. Owens, Barry Click, BARRIECLI.
Okay. Mandy says, please explain the state's filing about Marino. The Abraham Marino. Sarah didn't talk to him before Ellie arrived. His sworn audio statement does not say what the state is claiming. Well, we don't know. I mean, they made a note in there about that. I don't know, Mandy. I mean, Sam, what do you think? Do you know what we're talking about? There was
I need you to remind me what the filing was.
Okay, well, it's in the police report where it says on the police report that he had stated in one section of Chelsea's portion of the police notes on witnesses that he and Sarah did speak before police arrived, and Sarah was telling them that George had been pulling her hair.
Okay.
But I don't know and maybe she wrote it wrong, Mandy. I thought about that too. Maybe she wrote it maybe she said that a couple of days ago or something. I don't know, because it was in the police report, but when you listen to his recorded statement and what is on the paper with there's a contradiction there. But so I don't know if that's going to be, I'm sure the prosecution will the defense will pull that out and analyze it and beat it to death if there is a conflict there.
What is their filing though? Are they objecting to it?
No, there's no filing on it. There's no filing on it. His name is Abraham Marino.
Okay.
The state has just made notice recently that they have spoken to him again, and they will be. It looks like he's going to end up being a witness in the state.
Oh. Okay, so I get it now. It's not the state challenging something; it's the state saying that they're going to call him. I got you. That's the same
Yeah.
thing. Okay.
But Mandy's saying, we over here,
Right.
us that are like gurus with the case now, where we're like looking at every single thing.
Right.
We've noticed that discrepancy. Whether
Okay.
the defense notices or not, it's on them. But yeah.
Well, it
So I don't
doesn't
know.
mean that he can't testify. And if what he's testifying about, if the defense finds that objectionable, then they just object and they can argue it out. But we don't know what all he has to say beyond what you guys have seen in discovery already. And
I'm sorry, go ahead.
no, you're fine. I just want to say, please remember that, and I appreciate all you guys being so thorough. I am not as well versed in this case as you all are, so thank you for having all the details.
And what the state put out recently was a discovery thing to the defense, just letting them know that this is an update. We've recently spoken with him again, and I think it was just like
Oh,
days ago, and they're
okay.
putting them on notice. They didn't necessarily say we're calling him as a witness, but to me it sounds like that's kind of the way they're saying that we've located him and spoken to him recently.
Did they file an amended witness list?
No, I don't think they did.
Okay, well, if he was on an original witness list, they don't have to file a new one, only if it changes.
And
My
that's
cat
he's probably still at the dang apartment complex. Who knows? He might still
That
work
could
over
be.
there. You
It could
know?
be. Yeah.
Okay. Thank you for your super chat, Mandy.
Thank
Mandy
you.
let me tell you what, Mandy is detail oriented. I can tell by her comments.
Yeah. Well, all of your subscribers are. So Sarah didn't call Brian, then 911. When would she have spoken to Moreno? She was faking CPR when I don't know. I don't know the answer to that.
Okay, so Sarah didn't call Brian then 911. Sarah called Brian before she called 911. While Brian was on his way there. Well, no. Once Brian arrived, he told her to call 911, and he left the apartment because he only stood in the doorway right there, right? The foyer.
Yes.
She calls 911 and says while she's on 911 that she's doing CPR, but we don't know.
Right.
When would she have spoken to Marino?
Oh.
Oh God, I sound like
Would
Chucky.
it have had to been that day? Could it have been conversations from leading up to the time?
That's what I'm thinking. Like, did it happen like maybe the night before, the day before, or was Sarah this was the maintenance guy, right? So was Sarah out back smoking a cigarette that morning while she was trying to figure out what she was going to do, and he walks by? I mean, there's no telling. There's no telling. It would be interesting to figure out how that came into play, though, on why they stated that.
Is this the guy that was Georgia's friend from Philadelphia?
Yes.
Okay. Okay, that makes sense. Yeah, I would expect that they would. It doesn't necessarily mean that he has to testify to whatever he told the police. There could be more to what he has to say, because if he was the maintenance guy there and he knew George, he may have further insight into their relationship. He's not limited to testify to only what his statement to the police was.
Yeah, that's a good point, Yana. He did state in there. He's like, we knew each other from back in Philly when we were teens. We didn't really hang out. I only saw him when I went to Ace Hardware for stuff, and I saw him around the complex. We weren't hanging out outside of that. And you know what else, Mandy? A comment that I really wanted to push here is that there's a lot of question on this detective on the way that she did some things. She talked over people. She didn't allow them to finish their sentences. She gave them information before taking their statements. There's a lot of stuff there that she did that I didn't like. And I'm not going to sit here and bash her. I'm just saying the way that it was handled, it could be that might be why this was written the way it was written. It was done improperly. I don't know. There's been some people in the chat lately that have said, why are you bashing the detectives? If y'all know me from my channel, I don't normally bash the detectives. I just don't like the way this woman, when she's interviewing someone, like for example, the first time she came on scene to talk to Sarah, instead of saying what happened and letting Sarah speak, which is what you're supposed to do, because her story could change, because that's what they're wanting to happen, right?
Mm-hmm.
She says, Sarah, I understand this, and this happened. No, let Sarah tell you what happened. It's that kind of thing that just drives me absolutely nuts. And, behavior panel said it. These police departments don't have the money to get all these people trained properly in these interrogations. And it's a shame. It is a total shame.
I agree. And after you said that, I went back and I watched the behavior panel's episode on Sarah, and I watched them or listened to them quite frequently. And it does sound, from what they say, as though law enforcement is not properly trained in interrogations. And my colleague and I are constantly complaining about how they are done in our cases here. Because they don't if you would just shut up and let somebody talk, they will talk themselves into jail. You don't have to force them. You know what I mean? It's just like, sit there and let them talk. Sarah would have just, I mean, she spilled anyway. Excuse me. But yeah, the attitude does not need to be there. And I have yet to be impressed by an interrogation that I have read, watched, or heard in the state of Florida.
Oh, now you're coming for Florida. Okay, Sam. No, I'm just kidding. I'm just kidding. Y'all wouldn't believe how sometimes people get so sensitive in the comments about stuff that we say. So that's why you'll notice I try to be careful about how I say it now. But you
Okay.
can't please everybody. I can't please everybody. I'm sorry.
No, and I know a lot of people don't necessarily love that I work in the defense capacity, but I've been in this world for about 10 years now, so and
That's a
I
good
do
point,
love
too.
my state. While I love the shade she gave, yeah, it was kind of unprofessional. It was snarky. You think it was
Yeah.
snarky?
I'm
Yeah.
surprised she didn't write a letter about her.
Right?
But maybe there is one. We just haven't seen it because it didn't go to the court. I don't know. Maybe she'll bring it up on the stand when she comes and testifies.
Oh my goodness. That'll be
Oh,
something.
Lisa's calling me out. Look at this. She said, say
Oh, I know.
Yosemite.
Yosemite. It's
Yosemite. If it's Yosemite, why don't they put 2 E's at the end or a Y? That's all I'm saying, Lisa. That's all I'm saying. All right, let's
Penny
get back
C,
to this.
thank you for saying that.
CK had provided the total amount of clothing that they had that would fit Miss Boone, including shirts, pants, slacks, skirt. And that was the time where she would be allowed free reign and was going to have the shock device on her lower leg. I would ask that you can email Miss Click. You can find her information on the Florida Bar webpage and ask her if the public defender would assist you in provided clothing. They were going to while Miss Boone was representing herself, and I imagine that offer would still be extended.
Judge, and I anticipate 2 more pretrial hearings. 1 is the case management conference, and 2, if I file the motion to suppress the statement made during the interrogation, we would probably have to set a separate date. Can she wear street clothes at those 2 hearings?
If you could get it to her.
Okay.
So that's something you have to work with corrections. I don't know that they're going to let you do that.
Now, when it comes time to trial, she would like for us to have some makeup for her and somebody to fix her hair in a way that's presentable to the jury that she would like to be presented. Do I need to file a motion on that, or?
I think you're going to have to.
Okay. I believe that's all I have, Judge.
Okay. All right. Anything else, State, we need to address?
Okay.
All right. Anything else, Mr. Owens, or from your co-counsel?
No, Judge.
Okay. I will.
So that was that part of it. And now we're going to get into the battered spouse motion. Anything you'd like to say, Sam, before we close this particular motion off?
No, thank you.
Okay, and now we're moving on to this one.
That takes us to the notice of intent to rely on the defense of battered spouse syndrome. The original notice was filed September 6th. The state's original motion to strike was filed September 9.
Judge, just to interrupt, I also have this defendant's motion for enlarged time to address as well.
Yeah, I have that on my list, sir.
Okay.
Thank you. Thereafter, on the 15th, an amended notice of intent to rely on the defense of battered spouse syndrome was filed. On September 13th, the defense's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome was filed. And then I think it was this afternoon. Earlier today, the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome was filed. The court has reviewed those and all of the citations contained therein. Mr. Owens, you may proceed, sir.
Judge, I wanted to start my argument, and then Mr. Henderson, who is on the screen, is going to respond to the the state's
We don't need to listen to
pleading that they
Mr.
filed this
Henderson,
afternoon.
because he'll blow our eardrums out and we won't be able to understand him.
Mr. J, you have a problem with that?
The back and forth
I
between
know there's a rule in the
Owens and the
circuit about
judge,
one witness.
we do want to see that.
So you want me to take something off?
So just don't play the part where Henderson talks, because you won't be able to understand him.
Oh yeah,
And
yeah.
it'll
Well,
blow everybody's eardrums out. And the part that I think is important and interesting is the exchange that's going to happen between Mr. Owens and Judge Koenig.
correct. Okay.
Not, I still have no idea what Henderson said, and it gave me a headache to listen to it the first time. But this
He
is
said-
important. This is the crux of the case right here.
Right. He said, "Thank you. That's all, Judge." I don't know. Could have been Charlie Brown's teacher talking.
I know, right?
Uh,
Sounded
for-
exactly like that.
One attorney, I don't know what the administrative rule says about arguments. Just in court.
Okay.
He's arguing that one motion that they filed this afternoon that I've been working on these. He was working on that motion, so it's a separate motion.
The motion to strike.
The last motion whatever motion they filed today, Mr. Henderson, Tony Henderson here in the screen wants to respond to that. I'm
Okay.
going to respond to the ones that were filed prior to today.
All right. I'll allow it. All right. Go ahead, sir.
Judge, as you know, I filed my notice of appearance on August the 30th, I think 38 days prior to trial, knowing that the court had already made a ruling that you would not grant a continuance unless there was some type of exceptional circumstance. And Sarah Boone hiring or retaining or somebody pro bono coming on the case and representing her did not constitute exceptional circumstance. And so, as you know, we had the hearing after I'd filed the notice on August 30th. We had the hearing on September 3rd on my motion to continue. The court denied it. At that time, I explained to the court that I believed after my meetings, I think I'd had 4 with Ms. Boone, that she met the criteria for battered woman syndrome, but that I needed an expert. And we were vetting several experts at the time, 4 or 5 that we were vetting, and we needed more time to essentially pick somebody to go out and do an evaluation, an assessment of Ms. Boone to determine whether or not they would give an opinion that she suffered from that. Because, and I understand, the court denied our motion, so that left us with, we still had to give notice to the state attorney 30 days prior to trial of October 7, which I believe was going to be September 7, which fell on a weekend, which was that Saturday, I believe. So we got out of the hearing. I think the hearing was on a Tuesday. We had 4 or 5 days to file this notice, to timely file the notice. So looking at the file, I realized that Dr. Harper had the most time with Sarah Boone. Early on in the case, I think when Mr. Padilla was handling the case, she was appointed by the court to do an assessment and evaluation. And so I reached out to her, and she agreed to come down a couple of days after we had that hearing, and she met with and assessed Ms. Boone. I've retrieved all the notes, the prior notes, and then the notes from that meeting. And then on Friday, I spoke with her, that Friday, which I believe was the date that I filed this notice, September the 6th. That Friday, I spoke with her on the phone and immediately went down and filed the notice of intent to rely on the defense of battered spouse syndrome. We made allegations that Dr. Harper had formed the opinion that at the time of this offense, that Sarah Boone was suffering from battered spouse syndrome. And at that time, we gave the name of Dr. Julie Harper and her address where she could be found and located. And of course, the state has set her deposition for October 1. Now, the state has filed a motion to strike the notice of intent, alleging that we didn't give sufficient facts or evidence. But Judge, realized at the time, I was simply trying to get it filed because the last day was the next day, Saturday. And of course, I had just gotten discovery. Judge Creighton, we have not finished reviewing all the discovery in this case. I pretty much shut my law practice down to try to do it. I've gotten my staff, and we're trying diligently to go through all the discovery. At the same time, we realize that we've got to establish corroboration of the battered spouse syndrome from eyewitnesses, from medical records, from potentially neighbors, court records, her phone and the information on phone. So we're diligently trying, number one, to review all the discovery, which still has not been done. At the same time, trying to locate additional evidence that we could utilize in helping to establish the battered spouse syndrome. In addition, the state attorney yesterday filed a notice that they're amending their discovery, and all the jail phone calls, or I think they have the ability not only to call, but they have a tablet and they can text back and forth with third parties, that they have disclosed that they have, I guess, 4.5 years worth of communications between Sarah Boone and parties on the outside, and that some of that may be relevant to the case. And we were advised that when I got in town that I was to bring a CD, and I did this morning. I went to the state attorney's office and spoke with the secretary and explained to her that here's my CD, I'll wait. And I was willing to wait in the lobby to get this additional discovery when we have 19 days for trial. She told me that there was quite a bit of it, that she would try to get it to me after the hearing or by the time of the hearing. I said, okay. I left the CD. I told her she had my number. She could text me. I was staying at the Hilton across the street from the courthouse. As soon as she had it, I wanted it as soon as possible. A short time later, they have started, I guess, going through that material. Now they're sending discovery through email. I assume instead of the CD, they're going to do it that way. But we are receiving it. But just the volume of discovery that we have to begin with, we haven't gone through. The evidence we're trying to gather to corroborate our defense, and then additional discovery that we were noticed about yesterday. I didn't have time. I knew this had to be filed. I had one more day. As soon as Dr. Harper told me on that Friday, I knew I had until Saturday. I filed it. The state knew. They've had it 4.5 years. They prosecuted the victim in this case, Jorge Torrez, at least 3 times. I think there's more like 4 or 5 times. But they opened up a file. They prosecuted him here in this county for battery in violating the conditions of bond relating to staying away from Sarah Boone, but battery on Sarah Boone. They, if anybody, was well aware that there was a potential problem with the habitual nature in which Mr. Torrez beat on my client. In addition, my client expressed in the interrogation, which I know the court hasn't seen, please look at the videotape. Please look at my phone. Please look at the videotape. Please look at the photographs. I need my phone to show you. He comes at me. It was ignored. They've had all this evidence. They had to be on notice that this is a potential issue. And the reason being is all the lawyers that have been through this have appointed different forensic psychologists to assess her. The prosecutor that's not here today, that was here on September 3rd, when I mentioned the problems that we were going to have, getting an expert this quickly to form an opinion, said, oh no, Judge, we're not prejudiced. We've already got an expert. We intend to rebut any said opinion by an expert that she suffers from battered spouse. We're ready to go. We've got our expert. Such that they said, we don't even need a continuance. If in fact he finds somebody and they file something, a notice of intent to rely on battered woman syndrome, within the time limits, we're ready to go. We don't need to continue it. We'll have our expert. And as you know, they're requesting that their expert now be allowed to go to the Orange County Jail and assess Ms. Boone, which they have every right to do, since we have filed this notice. But they indicated they would not be prejudiced. They indicated they were on notice. They didn't think it was going to happen. 4.5 years, but it did. They knew all the prior abuse that Sarah Boone suffered at the hands of Mr. Torrez.
Harry, pause it.
I did the best I could, Judge.
I did the best I could, Judge.
So, you guys, have you noticed that he's not actually arguing anything? He's just kind of saying, well, you knew it was coming, except that in Sarah's interviews, she didn't say it was self-defense. She said it was unintentional. But the state's going to get up now and they're going to make an actual argument. Mr. Owens's argument is that it is what it is. I did the best I could with what I had, which is to say, you're not addressing the elements of battered spouse syndrome at all.
He's just rambling off a bunch of examples or cases that anybody, I could go and find that.
I didn't even think he was citing cases. I thought he was just saying all the places he went, and we know where he stayed. We know he brought a CD with him. What else? Oh, the
He's like
state's been
Sarah.
on notice for 4.5 years because they prosecuted George at least 3 times, but maybe 4 or 5 times. These are all not legal arguments.
And he's incorrect because George, technically, if you look back on the case dockets, George's cases, he did spend some time in jail, but he wasn't found guilty in all those.
Right. So I can see this trial will take 3 weeks because he talks so much. You think he's,
Yeah, I was saying that early on. I was like, oh yeah, this guy likes to talk. It's going to be just him dragging stuff out.
yeah, we're gonna need snacks.
And I love yes, plenty of popcorn, soda, chips, coffee, whatever you guys enjoy. I like to snap into a Slim Jim from time to time. Whatever it is you like, bring it. So I love Prosecutor Jay, and I like the way he talks back or snaps back at Owens a lot.
Well, you notice on his desk that he has like nothing except maybe a small laptop. So he's clearly prepared. Oh my goodness. All right.
It's hilarious. Okay.
Yeah, I mean, your chat is super sharp, but just notice that he's just saying words. He's not arguing anything. To me, it sounds like he's making excuses, but yeah. All
Yeah,
right,
like Mel says, I love Mr. J's sass. That's what it is. It's snass. Sass. All right.
Oh,
here we
yeah.
go.
Mr. J Sass, he is.
Filed it. I felt like I had to have an expert. I explained in general terms that she was psychologically and physically abused by Mr. Torrez repeatedly over a period of time that led to this event. They filed their objections, which we believe is misplaced. The court, as you know, by that rule, let me find it. It's apparent not only that the state was on notice, that we were going to rely on it, it was prepared to respond and was not prejudiced in any way. The notice of intent to rely on the defense of battered spouse syndrome comports with the requirements outlined in 3.201, given the current circumstances of the case. And as you know from that rule, it says the notice shall contain a statement of particulars showing the nature of the defense, the defendant expects to prove, and the names and addresses of the witnesses by whom the defendant expects to show battered spouse syndrome, insofar as possible. Insofar as possible. I did the best I could, Judge. In addition, as soon as we started going through the discovery and gathering information about the prior events, the prior arrest of Mr. Torrez, the prior prosecutions of Mr. Torrez, we immediately amended the notice on September the 15th of intent to rely on the defense of battered spouse. And again, listed as many witnesses as we could based on the good faith belief that we had that corroborated either by witness testimony or or physical evidence, photographs, videotapes, medical record, whatever we could find that would corroborate our defense. In addition, we've listed the ex-husband, Brian Boone, and the last paragraph, paragraph 14, says the defendant's investigation of evidence to support the defense of battered women syndrome is ongoing. The defense anticipates additional witnesses, photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be disclosed as it is discovered. Thank you.
Response, sir.
Judge, the state is not surprised by any of the evidence that has been in the discovery for years. I'm not going to belabor the facts in the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense. Their original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice, it still does not set forth what they are going to show that shows that she suffered from battered spouse syndrome. Was the decedent isolating her from her family and friends? Was he telling her that if she ever leaves him, he'll kill her? We have these instances of violence between the two of them. And when we get referred to the ex-husband, Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him, punch him, and that she was a habitual alcoholic. And he would have to lay hands on her to restrain her. So we are going to potentially dive into all of this information in trial, but there are still the rules of evidence. And the cornerstone for the battered spouse syndrome defense, which is a misnomer under the case law, because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence. The state and wherein our confusion lies is nowhere in any of the witnesses or any of the discovery that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence, before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered against her for her violent nature and her drinking. The cornerstone is self-defense. Her statement to the police is not one of self-defense. It is one of accident. She repeatedly says there was no violence that day. So that is where the state's position is, that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol related. But it doesn't go on to say this violence has caused her to suffer from the syndrome. And here's why. She was afraid to go meet with her family. She was afraid to leave. She was any of the things that make up what is actually battered spouse syndrome. And moreover, it doesn't set forth the self-defense claim, which is the cornerstone of this. None of this comes in without a claim of self-defense. And so that's in part why we filed our motion in limine with that response, is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night, is her. So she'll need to testify, and then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use. That's what we're hoping to avoid, because we can't unring the bell during trial. If they put on all of this testimony and evidence about battered spouse syndrome and about the past violence, and then we introduce evidence about her past violence against him and against Mr. Boone, it's hard to unring that bell. And even though King versus State, a 2000, I forget which year, 19 case allows the state to point out the things that are promised in the defendant's opening statement, but then don't come to fruition, that doesn't unring the bell. So that's what we're asking for. We're asking for sufficient notice. The statement of particulars that is required by the rule, where is it setting forth? There is a self-defense claim, and then there is going to be this shown beyond just the past violence between the two of them. Thank you.
You know what's interesting, Carrie, is that James Owens was arguing that he wanted a statement of particulars from the state so that he could give them a statement of particulars for the battered spouse syndrome defense. I just now realized that.
So what do you think about this?
Well, I mean, I think it's going to be a long trial, and it doesn't need to be a long trial. I don't see, I do not see the jury. I do not foresee a jury buying this if the entire, if her audio comes in, if her interrogations come in, and I don't know why they wouldn't, because I think there was a motion to suppress filed last night, but you already went over it, right?
Yeah.
Okay. So I don't even remember what the arguments were. Oh, coercion, right? Did he argue that she was coerced?
You have to forgive me because I've done so many videos in such a short period of time. I'm getting all these emotions confused.
I know you have. And I've got other cases tangled up in my head. So
Yeah, you do. I forgot about that.
I think that in the motion to suppress, they were trying to say, I think the main argument is that the female detective coerced Sarah and that the Miranda was improper. And
Yeah, it was
they're
the
trying to
last.
the
Sorry.
last statement or something.
Is the
right?
last. It was the part where it says, "Now that you've heard all your rights, or now that you've heard all these, do you now agree to talk to us at this time," or something like that. And that was that small portion at the end. But I've heard that doesn't make a difference. I've heard a lot of people say out there they've seen it in different cases and different trials, and it never holds water.
That's correct. But you know how I know chat's not paying attention? They're still talking about Sarah's hair, and they haven't told me yet what the motion said. Oh my goodness. Because I know they'd be on it, but they're talking about Sarah's hair.
Is that what the topic?
Yeah.
I'm sitting here scrolling through because apparently we had somebody say something nasty in the chat,
Oh.
and Laura had to boot them. So if y'all say something nasty, Laura's gonna get you. She
Yeah.
will get you. She will find you. I know y'all won't though, but I don't know who that person was. I've never seen him before. Okay, let's go forward.
Judge, they're scheduled to take the deposition of Dr. Harper October 1, so they're gonna know fairly quickly what her opinion is.
What's your response to Wagner?
We're going to talk about Wagner, Judge, and I don't want to talk about that in a minute, but he's bleeding the argument into state's motion to strike the defendant's amended notice. And I would like for Mr. Henderson to respond to what he said about that. But Judge.
Because I agree, there's two different issues here. The first issue is the sufficiency of the notice, and whether the notice is sufficient under the rule. The second issue from the court's perspective, is it applicable? And that's the hang up that I'm having.
That's not to be decided today. That's not Wagner, whether it's an accident or whether it's battered spouse.
Do y'all think what he just said there, that's not to be decided today? Don't you think that was kind of wrong, the way he said that to the judge?
Yes.
Is it just me?
No.
Okay. Okay. I thought that was very disrespectful.
There was self-defense. That's not to be addressed today or not to be decided today. That's going to be based on the testimony from Ms. Boone about what was going on. But I Mr. Henderson, if you don't,
But that's not what Wagner stands for. Wagner didn't allow. Wagner struck after multiple amendments, and the court, and we can take judicial notice of it if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse defense.
Judge,
The
but
issue,
ultimately, the female defendant in that case claimed that the firearm discharged accidentally.
correct.
And the court ruled, hey, you can't have it both ways. It can't be an accident.
Exactly.
At the same time, be intentional that you committed as self-defense because you're a battered spouse.
Right. So how is battered, even,
It's premature
making
for
my
them to
brain
be
itch.
arguing the question of intent.
but that's not not what Wagner says. What Wagner specifically says, although the trial court found the third
What'd I do?
legally sufficient, the court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence at trial. And the DCA says that the evidence underlying in that case was all accident. Specifically, the
It's their audio. I
it's
think.
located. Battered spouse syndrome as admissible where the defendant claims accident rather than self-defense.
We're not claiming accident.
Well, then what are you claiming?
Self-defense.
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused. And that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission the overt act was.
Show me the
Okay,
test
go ahead. I
answers
know you're
before I
done.
take the test. That's what he's saying. Show me the test answers, and then I'll take the test. You know,
Zipping him into the suitcase?
That's, but
Was that the overt
But
act
all of the
that caused the
But
death?
all of the battered spouse syndrome cases talk about a defensive issue. Not meaning defense, your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did. How is that applicable?
He found
Oh,
local-
shoot. I just hit the back button. Oh, doggone it. Okay. I apologize, you guys. I was trying to hit this pause button and I hit the back button. Sam, I've been wanting to ask this question that Shell Marie says, does she have to testify? If they're using battered spouse, does she have to testify?
I would
think I saw that.
so.
I thought I saw somewhere that, well, it shouldn't matter what defense they use as to whether they're going to testify. I guess that's just a matter of opinion.
I
mean,
don't
you can't
understand
say,
what you mean.
well, if she uses the battered, I guess the talk in the chat is if she uses the battered spouse syndrome, then Sarah has to testify. When using
Yes,
that defense,
that's
you
correct.
have to testify. You do.
Yes.
Okay. All right. I hope I
But
don't
it's
mess this
contradictory
up.
with everything. I mean, it just.
Yeah. Oh, yeah.
I
It's
read all
like,
the cases that they're arguing over. And one of the things the judge will say here is that your cases don't apply to actual trial, what comes in at trial. They're all pre-trial, just to mix things up a little more and make everyone's head explode.
all right. Tell me if I need to, and if you want to fast forward this a little bit, you feel free. I'm going to try
This
to
is
pick
the
up where
best
we left
part.
off.
As soon as they're done with this argument, we can get out of it.
Okay.
notice. And I would like for Mr. Hickman,
I think, oh, shoot. I don't know where we were.
they're scheduled to take the deposition.
Have we already done this part?
Dr. Harper, October 1. So they're gonna know fairly quickly
Yes.
what her opinion is. and
What's your response to Wagner?
Okay. So I don't
Wagner
know. Chad,
struck
did we already
after
hear this?
multiple amendments.
What?
I'm trying to ask chat if we already heard this part because my brain is not working.
Let's see, 1925. I'm gonna start at 1925. That's the only thing about this little.
And the
button.
court, and we can take judicial notice of it if
And
you
they were
want to.
arguing
The
back
court
and
has
forth
pulled
about
the
this.
file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse defense.
Judge,
The
but
issue,
ultimately, the female defendant in that case claimed that the firearm discharged accidentally.
correct.
And the court ruled, hey, you can't have it both ways. It can't be an accident. And at the same time, be intentional that you committed as self-defense because you're a battered spouse.
Right. So how is battered, even
It's premature for them to be arguing the question of intent.
But that's not what Wagner says. What Wagner specifically
specifically?
says, although the trial court, the third legally sufficient, the court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence at trial. And the DCA says that the evidence underlying in that case was all accident. Specifically, the
Okay. Sam, you see that question up there from Zombios. My question is, oh, Sam, you're muted.
Oh no, I unadded myself.
Oh, okay.
Yeah. Okay. Sorry. Question?
My question to you, Sam, is do you think the most recent motions to support will actually work?
To suppress?
I'm sorry, I can't see that it's covered up by my little thing. Is it suppressed? Yes.
No, I don't. Because it's missing argument. What he's doing is he's filing like bare bones without support. He's saying this, and this, but he's not supporting it with any law. And this is where you use case law to argue your position, is when you are filing a motion to suppress, and he didn't do that. So no, I do not believe it will work. I can't see the future, but in my opinion, no.
Okay.
it's located. Battered spouse syndrome as admissible where the defendant claims accident rather than self-defense.
We're not claiming accident.
Well, then what are you claiming?
Self-defense.
But every case that you cite, Medina, Hickman,
Oops, sorry.
its progeny, all pertain to some act by the accused. And that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase?
But
Was that the overt
But
act
all of the
that caused the
But
death?
all of the battered spouse syndrome cases talk about a defensive issue, not meaning defense, your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did. How is that applicable to the case at
I
bar?
assume they're going to say she overtly zipped him up in the suitcase. I assume they're going to say he was asking to be let out of the suitcase and she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torrez, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
are two peas in a pod, Stargazer. I agree.
Mm-hmm.
I had clipped some of this down previously. Hang on.
I mean, this is kind of a
Only
big
Sarah
deal,
Boone
though.
can testify to that. So the
So
act
they're saying she has to testify.
they have alleged
Of the battered spouse syndrome case, and that battered spouse is an excuse, a justification, an explanation for those actions. How is
Do y'all see now why I like to pre-record this stuff and put it out? I do not like to do this stuff on the fly. There is too much to look at in the chat, and then also with the video, and then try to also listen to what's being said. My ADHD is kicking in on it's in overdrive tonight.
Yeah, I feel you, because I'm not used to
your
looking
purported
at this either, this setup. So I'm
defense
trying to watch all the
applicable
things.
legally?
It's a
That's
lot.
the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase?
But
Was that the overt
But
act
all of
that caused the
But
death?
all of the battered spouse syndrome cases talk about a defensive issue, not meaning defense, your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did. How is that applicable to the case at
I
bar?
assume they're going to say she overtly zipped him up in the suitcase. I assume they're going to say he was asking to be let out of the suitcase and she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torrez, which they have alleged was directly caused by Sarah Boone's actions or non-action.
We're getting a bad feedback right now.
Yeah, I know. We just need to get through.
I mean,
this
not a
one
feedback,
little
but
part.
a lag. It might be because of the weather. It's the weather, I think. This is the part where I fast forwarded a while ago because there's this huge pause right here.
I just wanted to
Hickman,
see
the
what the judge
defendant
says.
stabbed the victim to death.
What now?
I just wanted to see
Thank you, Miss Barbara.
just want to see what the judge
Um,
says, and then we can be done with it, and we can answer questions. Carolina, I agree.
Yeah, exactly. She's like, I've watched it so many. I'm the same way, but like tonight, it's just late. I'm not on my game right now. Okay. I just did it again, y'all. I just did it again. Hang on.
So I think that Carolina also asked if I thought that Mr. Owens was going to wing it. He certainly hasn't been acting like he was, but now, like that he was projecting that he has all this professional power behind him, but that's not what we're seeing in the filings or here in court. We're not seeing that preparedness at all. Because if you guys watch this hearing, you'll know that he didn't have dates on anything. He didn't know when things had been filed. Carrie did that commentary about Margaret in the office. So I don't see how he can wing it at this point. I said in a different video or a different stream that in Florida, I can't speak to any state outside of Florida when it comes to this stuff, but what I have noticed is that lawyers get used to their judges and they get used to their courts, and they all have their own little way of working. His way in Pensacola is probably fine. It is not Judge Kranick's way. This is not acceptable. Do you understand what I mean?
I'm with you. I totally get it. He
Yeah.
thinks he's an old. Okay, I'm going to explain this in a way that's probably not going to come across well, but I'm just going to explain it the best way I know how to explain it. I'm from this area, like where he's at. It's like an hour drive, okay? And it's kind of old schoolish. It's good old boys. That's what we call it. It's the good old boy network, okay?
Mhm. Oh, 100%. Yeah.
And I can say this because I grew up in the good old boy network. I literally, unfortunately, a bunch of old school people are still living in that era. This man is
Mhm.
still living in that era. And
Yes.
him and his old school buddies are coming up there, and he's used to having probably judges that are his buds that, and I'm not saying anybody's doing anything unethical, but I'm not saying that they aren't. So yeah,
Yeah.
that's exactly what it is. And it's so rampant here in the South still with these older
Oh my
gentlemen.
gosh.
It's really
It,
bad. Just like the whole thing with bringing the female lawyers, legal assistants up there,
yep.
young and pretty. Yeah, that just
Yes. I encounter it. It's so bad with the older lawyers. For me, it's just horrible. They never they don't look at me side by side with another. They'll always go to the male before they'll go to me unless they want analysis of something. Then they'll bring it to me.
I literally at one time in Tampa, well, it wasn't in Tampa, it was in Bradenton when I was working in commercial insurance. I had a lot of great clients, and every now and then I would run across a client that I would have to bring my boss in on because it was a male wanting to hear from a male for what he needed. He didn't want to,
Exactly.
because no matter how much I was on top of his account and my boss would look at me for answers right in front of this guy, he would
Yep.
still speak directly to my boss and ignore me while I'm sitting right there. Yeah.
100%. Yep. Run
Yeah.
into it constantly. Constantly.
All right. So yeah, I lost our spot again. I apologize.
Well, so the end of this is that
I'm
the
assuming.
judge has
Let's-
done his homework.
Well,
Owens
we can
has
get to
not.
the we can do after this because really we've already heard the fight. Let's hear what the prosecution says. This is the end of what's his name?
Henderson. Watch your eardrums.
Yeah, hold your eardrums out, y'all, in case we have to listen to any of that.
It sounds like we're largely on the same page. The one point that I would strongly disagree with is that this evidence of battered spouse syndrome is relevant to the subjective belief of the victim or the defendant. That is not what evidence is used for. It's used to help a jury understand what an objectively reasonable person would do in those circumstances. And there's more cases that I have not cited because I didn't know that would be raised today, but they kicked out PTSD testimony just last year, I believe it's in Okendo, because it was going to the subjective beliefs of the defendant rather than helping the jury understand why an objectively reasonable person in a battered spouse syndrome would stay. With that notwithstanding, it appears we're on the same page that the jury should not be hearing anything about battered spouse until the predicates are laid. And from the state's position to help us prepare for trial, pleading should be sufficient. And it's still our position that the pleading was insufficient. The state is well aware of the past violence between the two of them, with her being the aggressor and the decedent being the aggressor. There's evidence of that all throughout the discovery. But what isn't present anywhere in the discovery and what left the state at a lapse in understanding this defense in particular was, did this violence cause her to suffer from battered spouse syndrome? And what is this evidence going to be? Was he isolating her? Was he keeping her away from family and friends? Was he psychologically breaking her down? Was he doing any of these things that are a component of the battered spouse syndrome? Because all we have is her statements, which are almost 100 pages long, to the sheriff's office, where she repeatedly says that night that nobody laid hands on one another. It was a great night. We were hanging out, drinking wine, doing puzzles,
Good day,
painting,
actually.
dancing with the dog. And then like everybody else, we were playing hide and seek, and he got into the
Everybody else.
suitcase and I accidentally went to sleep.
What?
He said, we're doing puzzles, we're doing artwork, we're dancing with the dogs, and then like everyone else, we're playing hide and seek.
Sometimes we get together and do couples therapy and we play hide and seek. Sometimes the whole neighborhood gets together. But you know, it's a small apartment, so we run out of places to hide.
Exactly. Good night, CB. Thank you for being with us.
Night night, hun. Oh, it's 3 a.m. there. Woo! Night night.
Mhm.
And then she's shown her video, but her statements are all that it's an accident and that there was never any claim of violence that day between the two of them. So that's wherein the state's confusion lies. And I don't know how we're going to go about this at trial, if the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently than how she gave statements to law enforcement. But that's
Okay,
where
do you
we're at.
understand
We
why
don't
she would
want this
have
in
to
front
do
of the
that?
jury until all
Say that again.
Do you understand why she would have to come in and testify in a narrative form?
No, please explain it to us just in case.
Okay, so the reason is because what he's saying here is if she's going to turn around and go back on it was an accident, she's not going to say it's intentional anymore. If she's going to try and say it's self-defense, then her lawyer can't put her up there because that's suborning perjury. So what he's saying is that she has to just tell the story. Her lawyer can't walk her through it because he knows, just like everybody here knows, that she said it was unintentional. You see what I'm saying? They're coming back around to the opposite of what they argued, or what she has been saying, what she said in her interviews. Yes, Refo madness, that's correct. It's why they're trying so hard to get the interrogation thrown out. Then she can say a completely different story. That's exactly correct. Yeah.
Okay, I'm gonna go grab a soda and hit play.
Okay.
all of the requirements are met. And as far as I know, the only person that can say that it was a justifiable use of force that night is her, because it was only her and the decedent in the home that night. And thus far, she has not made any statements about a justifiable use of force. And then our second complaint about the intent to rely on the syndrome, again, without repeating myself, is it just sets forth that there was past violence between the two of them, but no particulars about what actually makes up the rest of the syndrome. Thank you.
Any other final positions offered in rebuttal to the state's argument, either Mr. Owens or Mr. Henderson?
Well, I'll let Mr. Henderson go, but just as it relates to Ms. Boone's testimony, that's what jury trials are for.
Mr. Henderson, any further arguments, sir? You're muted. You will have to unmute yourself.
I'm sorry. Can you hear me now?
Loud and clear, sir. Any other additional?
Experts who know about these things and who have the knowledge, who can tie these things together and tell why she's of the opinion that she was suffering from battered spouse at that time. This is simply to require to let them know that we're seeking this avenue, and here are the witnesses that we're using to seek the avenue. We don't have to list a specific number of witnesses. It's just the ones that we intend to use. And as Mr. Owens has told you, this is an ongoing process, and we'll probably be adding more. But that's all I have. Thank you.
All right. Thank you very much. The court is going to take the issue under advisement and provide a written order. I'll endeavor to do that by the end of the week.
Okay. We're almost at the end of this. That was it, I think. He said by the end of the week. You there, Sam? You're muted.
I just was talking.
Yeah, I do that
and
all
I
the
was
time.
muted. So the judge reserved a ruling. We know that he came out with his order. I believe it was granting in part, denying in part, but I could be wrong. I've looked at it. I don't remember it, but let's just go through questions and then everybody can go to bed. So Zambios says, so they need essentially an interrupted version from her so she can't be led, so to speak. It's that she would be saying that she did this in self-defense, that it was not an accident. And because the lawyer knows, everybody knows, but the lawyer knows that she has been saying it was unintentional, she turns around and says it's self-defense. That's a lie, and a perjury is lying. And so the attorney can't get up there and ask her questions to pull that information out of her. That's called suborning perjury. So she has to testify in a narrative form to avoid that, because the lawyer does not need to go to jail.
Thank you for your super chat, Mandy.
Is there ever a justifiable use of torture? No, I don't think so.
Did he roll? Let me see. Go ahead. Go ahead and finish that. I'm looking up something while you're talking to the chat.
She tortured George to death while laughing and taunting. Is Owens high? I don't know if Owens is high, but I think that the judge probably came down off the bench and needed a drink because he was turning bright red.
Are you scrolling through to find questions? Y'all go ahead and put your questions in the chat for Sam.
Oh, here. They're all in the starred section. Okay.
Oh yeah, I did a lot in the star section, but
Yeah,
we might have
so I'm
already
just gonna start going.
covered some of these already.
Thank you, Shell Marie. Carrie is fun and fabulous. So thank you for joining us. Is this the Boone Club, or we already saw that? Let's see. He gifted. Thank you so much. Yeah, I think we've seen all of these. Yep.
Okay.
So if anybody else has any last questions. Let me see. Yep. Okay.
Order on state's motion to strike defendant's notice of intent to rely on the defense.
Yeah. So that was the judge's ruling.
Okay, let's bring this up really quick because I want to finish it off with this.
Okay. Yes, zombie. Has he made a ruling on interrogation being thrown out? Not to my knowledge. This was a motion on the order on the state's motion to strike the defendant's notice of intent. So no, he hasn't gotten to ruling on throwing out the interrogation, which I believe has been filed because I think I read it. But this, he just goes through and he grants part and denies part, I think, if I'm not mistaken. But I'm sure you guys probably know better than me. Ozzy, so this is his order from that hearing, and then anything that's been filed since that hearing by either lawyer, by either party, will be ruled on either tomorrow or in writing.
Okay, so he's basically saying that.
Yeah, keep going. He's just restating the facts. So
Okay, sorry.
he states all the case law, which if anybody's interested in the case law, I think it's in Buy Me a Coffee. So he's saying that the notice and the amended notice, which are for battered spouse syndrome, he's saying the state, you don't get to strike it. It's going to go forward. And the state's request to stop the defendant from mentioning battered spouse syndrome in her opening statement is denied. And the state's request to prevent any mention of battered spouse syndrome until admissible evidence of a justifiable use of deadly force is admitted into evidence at trial, and admissible evidence of battered spouse syndrome is admitted into evidence at trial is denied. So basically what the judge is saying here is he's letting Sarah go with this battered spouse syndrome with self-defense.
I'm glad too. I mean, and I really think that if he wants to go that route, let him. And I just think the jury's going to be sitting there shaking their head going, what? They're going to, they're going to see, because we're going to see, you could take out pieces. You could take out one interrogation. You could take out this or that, but they're going to see there's so much on audio and video of this case that they're going to hear all that and go, that doesn't make sense with this. That doesn't make
Right.
sense. And I guess during the trial, well, like I guess tomorrow, well, Friday, not tomorrow, but Friday they'll be arguing all this stuff back and forth as to let's get down to specifics. Or I want them to strike this portion of that interrogation. Will they strike it? I don't know because I feel like we're going to get there eventually, right? I mean,
Um,
go ahead.
yeah, so tomorrow would be the date for, except Owens keeps trying to push things, but tomorrow would be
Their
what
deadline.
I would assume is that would be the motions argument, what's in and what's out. And then
Yep.
because it sounds like the judge wants to start immediately with jury selection on October 7th. So a lot of times attorneys will come in before a jury panel is brought up and they will be arguing motions in limine, trying to get things, suppressed at the last minute. So
Exactly.
it's going to be really interesting. I mean, nothing about this case has gone the way you would think. Ozzy says, you made me think BSS was denied. You put that in your thumbnail, but it was granted.
Did I put that?
It's granted to proceed. Yeah.
Did I put that in the thumbnail?
I don't know.
Shoot,
I was
I gotta
not
go
in
back.
charge of that.
I gotta go back and look at that.
Okay.
I was thinking we got something granted though.
Um,
We got something denied. What did he deny? He denied the one from earlier, the enlargement.
yeah, no enlargement of time.
Yeah, I think I just kind of I was typing that. I gotta fix that. Okay. Well, sorry guys. I am not on top of my game tonight. We've had some crappy people in the chat that always brings me down, and yeah, this is why I don't
Yeah,
like to
and
do
I
live
had some
streams.
technical issues, some
So,
cat
we're
issues.
going to. Yeah, Sam's always coming in, bringing her drama. Like we needed more. I'm just kidding. Thank you, everyone, for your chats. Mandy, thank you for all your super chats. That was very kind of you. Let me thank the last. It was also Barbara Seals, Miss Barbara Seals. Thank you for all your super chats, sweet honey. Route Irish for your super chat and your freaking 10 gifts. That's awesome. Thank you so much. Welcome to those that are new here. And if this is your first time listening to us live, please give us another shot because this was not our best.
No.
This was not our best moment.
No, it wasn't. But thank you so much for being here.
And with that, we will see you. I'm going to be putting some more stuff up. What do y'all think about the small clips that I've been putting up? I think they're doing pretty well, the shorter things. And then I'm going to be putting some more of that up before tomorrow. And then on Friday, of course, we will be back for the live stream of the hearing, which is going to be very interesting. And let's hope they get that dad blasted Zoom fixed.
Exactly. And Carrie, we need to figure out when we want to do our salacious speculation stream. Because that'll need to come before trial.
What do you mean you'll miss us? Are you going somewhere, Mandy? Love your. And by the way, if this is your first live stream, I always say I'm leaving and then I stay on for another 15 minutes. That's just how I don't mean long goodbyes is a Southern thing.
Mandy
totally
is
a Southern
saying,
thing.
she said just a minute ago, I think, what are we doing after Sarah goes to prison?
Oh, you better stick with us because you know what? We were going to talk about some other trials that we were looking into. And I noticed something. I started watching on Amazon Prime videos. I'm sure you guys have seen bits and pieces of this, if not all of it. Have y'all ever watched Killer Women with Pierce? What's his last name?
Piers Morgan?
Yes. Have you ever watched that? You know what I
No.
noticed? There was a lot of those chicks on there that are from Florida, Sam.
Well, it's in the water, I think.
Well, yeah. But I just thought I don't know why, but I really like doing these women cases. Why are women women are vindictive and they're, I don't know.
Yeah, we're
It's
seeing
just,
a lot of high profile women cases right now. And I don't have any female defendants and haven't had in a very long time. And I've never taken one to trial. But I've got a lot of murders a lot of attempted murders, but none of them involve a female. Oh, no, wait. Two brothers pulled guns and one of them shot their sister dead. So there's that.
Oh.
But yeah, she's not a defendant. Oh.
Thank you so much for becoming a member, Penny C. God bless you, honey. I promise it gets better than this. Alexis W. said, we missed Sam's question. When will we do the salacious stream? Okay, so let me explain that really quickly, and I was going to put out another video on that. What are we calling it, Sam?
Salacious speculations
With Suitcase Sarah. And
Suitcase Sarah.
We're going to do it on Monday night, and it's going to be a live stream. God help us. You guys need to email me. I've already started getting emails from people. I want your theories. I want to hear your theories on how you think the crime occurred. And when I say that, I mean like that evening, where she said we were doing this, we were doing that. We know that at around 7 p.m.-ish, according to Vinny, things started getting loud, right? What happened? Hey, Steven, good to see you. What happened? What did the suitcase go down the stairs with him in it? Did he get in the suitcase upstairs? Did he get in the suitcase downstairs? We want everybody's theories. And what we're going to do is we're just going to have a big old theory, speculation live stream about what we think might have occurred that night. Because we know that Sarah's nothing but a liar. And what's my email? It's in it's in the description of all my videos. So you can go in there and find it there. And the way we're going to do it is, if you're a member, of course, you're going to get priority on whatever your theory is. We're going to do at least one of your theories first, and we're going to move on to the next person and the next person. But I do love, I just reading the comments and going through and listening to what you guys have put in there before. And they're all over the place in my videos. So to go back and find all of them would be impossible. So that's where I need your help to kind of get them all in one space so we can focus on them on Monday night. But yeah, I'll put the live stream up here over the weekend, but it's definitely going to be Monday evening. And you guys have just been so, like, somebody will say something and I'm like, oh my gosh, that makes total sense. I never thought about that.
I've had great comments in the comment sections on the videos, Carrie. Everybody is so engaged and asking great questions and making great points. It's been super fun.
And I wish I could go through all of the comments, but you guys, since we started doing this case, my channel is kind of blown up as far as it for right now anyway, while we're doing Sarah Boone. It's been very busy. There's a lot of comments and it's hard to go through all of them and still kind of try to keep putting content out for you guys. Thank you, Penny.
You can't do everything? You can't do everything?
I definitely can't. And I do have my days, like my moments like now, where I need coffee, but
it's time to go to sleep now.
No, it's only 9 o'clock, and this is when I get a lot of my best things done.
It's 10 o'clock for me and past my bedtime.
Well, but you don't have to go to work tomorrow, do you?
Well, I never go to work because I work from my home unless I'm in jail, at the jail, or in court. So yes, I do need to work. It doesn't matter that the court is closed. I have thousands of pages of discovery I need to get through on several different cases.
Thank you, mods, for riding the storm out. Yes, absolutely. Thank you, Deb, for bringing that up. We have some great mods in here. We have Laura and we have Bama. And yeah, if people are rude, I don't care. I just won't tolerate rudeness. It ain't happening.
There's no need for it. Go hate somewhere else.
They'll be booted. There's too many people that are kind, and I think that's how we've kept we don't normally have that big of a problem with people being rude in the chat, but every now and then it happens, and it's just going to happen. But that's why I stay away from Twitter, you guys. Well, I don't stay away from it. I have to post my videos and stuff on there, but I'm not a fan of Twitter.
No.
Yeah, Laura had to put the hammer down a couple times tonight. She did. So
thank you, Laura.
Thank you, Bama. Thank you, Laura, for all you do. Crazy KC. Crazy KC is also our mod. She just retired from her job, so she's going to be on here more and more.
Oh, nice. Okay, good.
So, Steven says, I break for mods. I've missed you, Steven. Where have you been? Don't do Twitter. I know, right? It's just Twitter's too political, and y'all know how I feel about politics. I don't like to on my channel. But I do have to post the video, and I don't really think many people, they're not as into true crime on there either. But oh, what I was going to tell you guys, one thing is that, like, I'm not a big, I go into Reddit every now and then, but the problem is if I go down that rabbit hole, I can spend tons of time down a rabbit hole that leads to nowhere. Okay. And so I'm trying to focus my time on getting you guys quality content at the same time. So if you guys are on like a Reddit thread or something and you think that any of the videos that we do would be valuable there, please share them for me. Same goes with Facebook because I'm not on Facebook. So if you could share some of these videos in Facebook and help us build our channel, that would be amazing. I appreciate you so much for that.
I am on Reddit. I will not tell anyone my username. So I do skim the threads, or the subs, so I'll make sure to keep an eye out for you, Carrie.
Oh, thank you. Yeah, just share like one of our videos when something comes out. Just click because I can't go in and just start posting videos. They'll boot me. They don't like that. So,
Yeah.
Carolina says it's only 7 p.m. here. Well, girl, I'm so sorry. All right. Well, y'all have a blessed evening and be on the lookout. I'm going to try to get as much out for you guys as I possibly can over the next 2 days. And we will definitely be back for the hearing Friday afternoon. That live is already up on my channel. So if you go in there and click it and click the notify button, it'll tell you when we go live. Y'all have a blessed evening. And thank you, Miss Sam, for all that you do with our channel now.
Oh, well, thank you for allowing me to be here.
Bye, y'all.
Bye.